Hi, everyone. Thank you for joining us. This video installment is put out by the AHLA Antitrust Practice Group, and it's the second of two videos we've done on the Sutter trial in Northern California. So the first video was a brief one, gave an overview of the case. If you want more backdrop, I suggest you check that out, because today we're going to talk about how the trial went, the results of the trial, and maybe some takeaways that practitioners or companies in this space might want to keep in mind. So we're going to take sort of a roundtable format to this today. So I have two really fantastic professionals here from the healthcare antitrust space. Michelle Hale, who's a partner at Wilson Sonsini, and Paul Wong, who's a director at NERA. And I'm going to let them introduce themselves, and then we'll dive right in.
Hi, Kai, thank you so much for asking us to join today. Looking forward to the discussion. As you noted, I am a partner at Wilson Sonsini out of our DC office. And prior to my time in private practice, I spent a decade at the Federal Trade Commission working with many healthcare matters, including lots of hospital mergers. So happy to be here today and kind of treading old and familiar ground.
Thanks, Michelle and Kai. I'm also very happy to be here, happy to talk with you. I am an economist and an expert that really specializes in healthcare antitrust matters, like this case. I do a lot of M&A work with hospitals, insurance companies, physicians, and then a lot of also, antitrust matters in healthcare, monopolization cases, questions of foreclosure, questions of conduct. So really interested to be able to talk about this a bit.
Thank you both for being here. And again, my name is Kaj Rozga. I'm from Davis Wright Tremaine. And quick disclaimer, none of us were involved in this case. We are just armchair quarterbacking here. Please keep that in mind. And I don't want to bury the lead. So it was a 5-week trial, and it was a complete victory for Sutter Health. It was a jury trial, and the jury decided entirely in Sutter's favor. So what is this case about? Brief overview. Again, go back to the previous video for more detail, but this is a class action lawsuit filed by consumers. And here, consumers are health plan subscribers in Northern California. And the defendant is Sutter Health, a large healthcare system in Northern California. And the plaintiffs essentially entered this case with two main theories of how Sutter Health monopolized healthcare markets. One was that they engaged in tying, unlawful tying, by engaging in all or nothing contracting with payers, which means requiring all hospitals be in network in order for any of them to be in network. And the other allegation, or main allegation, was that they also, that the hospital system prevented payers from engaging in steering of patients within their network to different providers, mainly to send patients to, or subscribers to, lower cost hospitals. So the theory was that this inflated the cost to insurers, and that was passed on to subscribers in the form of higher premiums or cost sharing. That was the plaintiff's theory. The jury did not accept it. It ruled entirely in favor of Sutter Health. The verdict form had 9 substantive questions. The jury answered the bare minimum. They answered 2, which was enough to throw the case out, because those 2 questions were really fundamental threshold questions of, 1, was there tying? And 2, was there anti-steering provisions in the contracts that Sutter Health had with these payers? And so what I thought we would start the discussion is exactly there, which is this question of, was there tying? Was there anti-steering in the contracts between Sutter Health and payers? And there, we actually saw a shift in the plaintiff's theory as the case proceeded, which may help explain the outcome. And so to sort of help us understand that shift, I thought I would start by asking Paul, what is all or nothing contracting, and what is it? How do you compare it to system-wide contracting, which is what the case sort of morphed into over time?
Yeah, thanks, Guy. That's a great place to start. And let's start with, I guess, where we ended up, which is system-wide contracting. What does that mean? And I think at its heart, it really just means there's a contract that covers multiple hospitals. But that fact alone, I guess, as we saw here, really isn't enough, right? You could have a master contract that applies to lots of things, but have lots of customization of different prices, different terms, different participation for each hospital that's part of that master contract. So simply saying there's one contract really doesn't ultimately get to the conduct or to the economic question that was really at issue. And I think what the plaintiffs had set out to prove was really there was something more. There was this sort of forced standardization or sort of suboptimal customization that wouldn't have occurred. And I guess a credit to the defendants here, they successfully argued and convinced the jury that no, yes, there was maybe a master contract, but there was actually a lot more variability than I think plaintiffs set out to first prove.
Yeah, that's a really good way of putting it, Paul. And I guess, Michelle, I was curious to hear your thoughts on, what is the testimony that ended up coming out, and how does it explain the verdict on these sort of threshold questions of whether there was, for example, all or nothing contracting, and specifically, sort of, how do you view that shift in the theory as potentially explaining the outcome here?
Yeah, so I mean, I think to pick up on what Paul said last, there could be a layer of complexity below a system-wide contract, right? And you saw kind of in a lot of the fact witnesses questions about whether they had examined the contract and whether they had looked at that complexity and whether, that in and of itself was a problem, right? And it didn't seem that there was kind of a level, that next level deeper to kind of really examine the prices. And I can understand, I'm sympathetic a little bit to the plaintiffs here because I think what they were doing was really, really hard. It's hard to get class cert. It's hard to get damages cert. It's hard to establish a pass-through from the insurers to the end consumer. It's hard to face a case where the insurers are kind of your key witnesses, and there's a real kind of credibility problem, I think, from a jury's perspective, that insurers are not particularly sympathetic witnesses, right? And that was like key and critical testimony that the plaintiffs needed to rely on. So I think, absent a really strong frame of how competition in these healthcare markets works, it was probably hard for the jury to figure out how to kind of put all the pieces together, because you did have testimony and facts come across that the hospital was able to impose, to leverage its position in negotiating with the hospitals. Negotiating with the insurers, whether to include more of its hospitals or the terms that it wanted, or resist steering mechanisms. And the question then becomes, how are they able to do that? I think it seems like, of course we weren't there, but it seems like in reading through all of the material about this matter, the defendant's themes were pretty strong, and they come through in all of the press, whereas you don't really see the same thing come across from the plaintiffs. And I think they just had a very, very hard road to toe, because the hospital pricing is incredibly complex, and it's hard to deconstruct that. When we were bringing hospital merger cases, we were lucky to not be in front of a jury. I would say.
Yeah, bench trials, right?
Right.
Yeah, I mean, what struck me is that, it seems like ultimately there was not testimony indicating that the insurers were forced to include all of the hospitals, right? That there wasn't actually a forced sort of compelled tying of hospitals in one market to the other. And so that seems to have caused the plaintiffs' counsel to have to sort of develop their theory and rely a little more on, for example, the anti-steering part of their case, which, you know, as a trial lawyer, you know, it's probably, I guess you could say it's not surprising as a trial lawyer to see that a jury may not react well or positively to seeing a promise made at the start of the case about what it would be about, and then seeing even slight deviation from that, you know, by the time you get to closing. So again, without speculating or pretending like we know exactly what the jury was thinking, I guess I would just say I wasn't surprised that that sort of inconsistency or evolution in the theory, although perfectly permissible, right, as a matter of law, might have, you know, had some impact on the jurors. And so, yeah, I guess my other question, you know, this one's really for Paul. You know, so if you're in the plaintiff situation here and you're seeing that the fact evidence, the witness evidence coming from the executives, from the insurers, if it's not really putting together that story of being compelled, right, of being coerced, I think that was the word you used. If you're not seeing the fact evidence sort of giving that narrative very explicitly, can economic evidence or can expert testimony from economists help connect some of those dots and still push you across the finish line?
Yes, definitely. And I think it's a good thought. I guess I'd first say, you know, as a general matter, this is true in a lot of tying cases, right? Where, you know, there's the notion of sort of literal tying, and then there's a notion of some sort of economic tying, which may be more nuanced, but still achieve a similar outcome. And so it's often the case that the economist is brought in to really kind of explain what might be happening under the surface in sort of in an economic sense that achieves tying. And so sort of specific to this case, you know, there were multiple contract provisions that were really at issue and multiple practices at issue. And kind of as the economist on the plaintiff side, how you connect those different things and sort of say, this is how they all work together, can be an interesting and complicated economic question. And yeah, I guess I'm sympathetic to that exercise. You know, it can be really complicated and there can be a lot of trade-offs you need to take into account in trying to understand what was the effect of a certain behavior. I'll also say, you know, on the defendant side, there's equal complexity, because certainly there's a question or there's an allegation of coercion, but particularly insurer hospital contracting is a contentious negotiation. And there can be some difference between what one side strongly prefers versus true coercion, and sort of teasing that out and saying, you know, is this really a coercion case, or is this just at first glance, you know, somebody doing something they'd rather not do, but eventually negotiating an efficient outcome? You know, that's a tricky call and requires a lot of analysis. And I think that really came down to one of the key issues in this case. You know, okay, you saw insurers having a particular way of wanting to contract, and you had Sutter having a particular way of wanting to run its system. You know, where those had to compromise or have to meet, is that outcome the results of kind of coercion and one side winning, or was it really a give and take in what's a very complicated negotiation process? And I think that's that's a question where you really need an economic expert.
Yeah, I mean, it seems like one of the main themes already coming out in this discussion is complexity, right? And really, we as lawyers or economists, we're used to probably communicating with sophisticated in-house counsel, federal regulators who specialize in antitrust. You know, a bench trial, we have a judge who we spent months educating. Totally different situation to have a lay jury, right? So, sort of thinking about the complexity, this trial, obviously, even though it ultimately by the verdict, it came down to these two simple questions. Is there tying? Is there anti-steering? No doubt, and we can see in the record, significant time was spent on other elements of antitrust claims that would have had to be proven here, right? Even if you had a jury verdict that said, yes, there was tying, there were still additional questions they would have had to answer yes to in order to establish a violation. So there were questions of market power, foreclosure, harm to competition, causation, damages, all these things. We now will never know what the jury would think about those issues. But the evidence came out and the jury heard it, right? They heard it through fact witness testimony, they heard it through expert testimony. So I'm wondering, and maybe Michelle, we can kick this off. I'm wondering what you think the impact of all that testimony might have been. We can't really get in their heads, but all we know is they voted no and no to these two questions of whether there was tying and whether there was steering. But we can still sort of maybe have a bit of a thought experiment about what impact all that evidence might have had in influencing how they ultimately decided the case.
Yeah, I mean, I think, one, I guess the elephant in the room, to use the defendant's lingo, is Kaiser and how you think about Kaiser. I thought in thinking about this case, I wondered whether the outcome would be different if it were a hospital system with 33 hospitals on the East Coast without a strong vertically integrated provider constraining the hospital, because it undoubtedly does. And I think, it is the case that that Kaiser can be a strong market participant and also not a competitor, and that Sutter could have market power. And those two things they're not binary. They can coexist. But I think it's hard when you're making kind of an up or down decision on a legal claim, how to factor in all of those different components. And the testimony that some of the testimony that came out, would have been testimony that I would have loved to see when I was at the FTC. That would have been incredibly useful to use to block a deal. But that this is a different context. It's a different legal standard. And, it also made me think, as a practitioner who is busy defending companies in front of the FTC and DOJ all the time, the chair of the FTC right now is out there saying the current laws don't really allow for damages. They don't really allow for us to fix the bad anti-competitive conduct that's out there, and that this could be, I could see her using this as an example, whether I agree with it or not. And I think, although Sutter won, as a practitioner, I worry about the level of exposure and the things that came out in this trial. Some of the party admissions that came out that were just covered in the press. There are some really kind of problematic things. Not being a juror, I don't know how they reconciled all of those things, but I do think that that the defendants played the Kaiser card really, really well, and that probably complicated matters for the jury.
Yeah, I mean, having grown up in California, I don't think you can drive very long on a highway without seeing a billboard that mentions Kaiser Permanente. Maybe that's not obvious to people in the other half of the country, but yeah, they're a huge force out there, right? And so this question of sort of market power, I totally agree with that, Michelle. That the question of market power was sort of lurking in the background the whole time, which is does Sutter have market power, even if it doesn't matter if they didn't tie? But I have to imagine that the jury was thinking about what's the nature of competition between Sutter and other providers, and what is the position that they have relative to the payers they're negotiating with, and that must have somehow seeped in to their sort of analysis of these sort of more fundamental questions. Paul, does that jive with your sort of thinking about the case, or how do you see it as an economist? Like, how do you make that leap from, okay, you have a big company, it's a big defendant, okay, you tell the jury as a plaintiff, big is bad, okay, now you have to say, how does that link up to something that's anti-competitive or harm to competition? that coercion that you were talking about earlier. I mean, how do you see that playing out? How would it potentially play out in a case like this?
Yeah, and I mean, I think this is where you have I guess a fun economic question, and maybe my sense of the word fun's too perverse. But I think you have two theories of the way competition works, right? And you have, from the plaintiff side, you had, well, yes, Kaiser's big, but they're different enough that they're really not a competitor in the way we might want to normally think of competitors. And on the defendant side, you have really, okay, at most, this is sort of clash of the titans, where you have this really, really fierce competitor in Kaiser that has an undeniable influence. And kind of, I guess, where it's fun is the economist gets to come in and sort of explain the theme of the day, complexity. You have this really complicated system. You have a complicated process of competition. How does it work, and what really matters in the end? I think it's an interesting and ongoing question that, yeah, I would also say, I think it can, the debate can generalize to other parts of the country. And increasingly you do see more, if not vertically integrated systems, sort of changing the way the healthcare delivery system works. And sort of what that means for kind of the debate of competition is an interesting one to watch going forward. The other thing I'll say, just as sort of an issue that it's hard to know exactly how much weight it played, but we can all think it probably influences to some degree, is, that in every healthcare antitrust case, there's a question of, is healthcare different? Are motivations different? Are the players more altruistic? What does it mean to have a nonprofit? And I think that in some sense, that's sort of the wild card, right? There's, particularly on the economic side, there's models of how that might matter a lot, but there's also models where maybe it doesn't matter so much. And I think, especially in sort of jury trials where you have likely a variety of opinions on that question, it's kind of a wild card. What does it matter that's a healthcare case, and is that really something special, is something you always have to kind of keep in the back of your mind.
That's a great point, Paul. And I think, I'm sure Michelle would agree with me that at the FTC, we would hear the nonprofit argument a lot when we were investigating hospital mergers. And you know what, from the regulators, you get a shrug, you get a, well, so what, not for profit, you still have a dynamic of negotiations to be in network. Whether you're nonprofit or profit doesn't really impact things. But this is one of those rare situations where the audience isn't an expert audience, right? It's a lay jury. So yeah, I think it's not a surprise that the defense pushed really hard on the nonprofit status, the charity care, the government care offsets that they have to do. So yeah, but we'll never know, I guess, how much that influenced things. But I guess maybe an interesting takeaway for people who might be defending such cases in the future.
Yeah, and I'll say, I think that's what makes healthcare a bit special, is kind of, there is the question, there is more of a human dynamic, I guess, to some of it than it is if this was sort of a commodity case. And
yeah,
it's hard sometimes to know just how much, the various audiences, whether it's a jury, whether it's regulators, whether it's a judge, how much weight they'll put into the kind of human aspect in a given setting. But it's definitely something to kind of keep an eye on for future cases.
Yeah, and the human aspect weighed against the fact that you do have a clash of titans. You have large insurers, you have large healthcare providers. They're engaged in tough negotiations. You can almost imagine a juror throwing their hands up and saying, "Why am I going to get in the middle of this?" As sort of if you put yourself in the perspective of a jury, you can imagine someone walking away from 4 weeks, of hearing evidence on these issues and sort of maybe saying, I'm not sure if I want to really get involved. But that takes us to the last topic, which Michelle, I'd love to have you. I'd love to hear your thoughts. Representing clients in this space, what are your takeaways? Sort of, I guess there's two ways to think about the takeaways. One is substantively, what does this mean for providers who want to engage in system-wide contracting or have anti-tiering positions that they take in negotiations with payers? And then maybe more broadly, what does it mean for assessing or approaching a trial or sort of tactical decision-making for healthcare trials?
Right. So I guess on the first, I don't think, to your point, Kai, I don't think that this case provides a lot of direction for us, because while Sutter won, I still think that I don't think I'd change my counseling practices for my clients. I think, the calculation has to be, these are risky strategies to employ. You need to consider the features of the market where you're operating when you're considering these features, these contracting features. And you need to really have a robust calculus of what your risk is once you do those two first pieces of analysis to figure out whether this is something that you would be kind of willing to take to the bank the way that Sutter did. And, then from a litigator's perspective, again, I commend the plaintiffs because I think they had a really, really difficult road to hoe. And the fact that they got all the way through it is remarkable. But, and from a defendant's perspective, there's a lot of exposure. There is a lot of really ugly stuff that came out of this case for the defendants. To the point that Paul was just making about the human element and the nonprofit perspective and the do-gooder arguments that come out of defending healthcare clients. You have an opportunity there where the plaintiffs are going to try to poke holes in it, and they did. They successfully did, and the hospital system's quality was called to question a number of times. There was a big sideshow about how its nurses and staff are treated and paid. These are kinds of ugly things that have, exposure and risk for the client in a non-antitrust setting that will continue for years. And you might really not want your business. It's going to be disruptive to the business and kind of on an ongoing basis. So I think, the takeaways are really, really analyze your risk tolerance and the necessity of having these kinds of creative contracting practices. And then also have a really robust compliance program. Do your antitrust training. Focus on document hygiene. Do the things that you need to do to make sure that if this underbelly does get exposed through litigation, that you're on your P's and Q's.
Yeah, that's great, Michelle. Thank you. Yeah, I mean, it's, on the point about the gray area, I think you need to point nowhere other than the fact that we have a jury verdict that has absolved Sutter Health for the exact same conduct. I mean, literally, I think you line it up, it's very similar. That a California AG-led case led to a massive settlement and required ceasing some of this very conduct. So definitely a gray area for us as lawyers. But Paul, I guess for the final word, as an economist, what are your takeaways? What kind of advice how would you approach advising a client in this area, maybe differently or maybe not, based on following this trial?
Well, I'll say, I think it goes to that gray area. And I think economists certainly have a role to play in navigating that gray area, right? And I think, you have Sutter, multiple cases as sort of potentially some guidance there. You have other cases around the country where there are instances in which sort of restrictions on steering or restrictions on behavior or pricing, they do occur and they're allowed, they're actually, justified. And I don't think there is clear general guidance at the moment as to when to pick one scenario versus the other. Certainly, we can dive deep into a case and figure it out. But I think, the whole profession, be it attorneys, be it economists, can have some work to do and, trying to set out some general guidelines about when is it good to have some restrictions, when might it facilitate a lower price or better quality, and when is it harmful, when does it impede competition. And I think at the moment we're left with, you really have to dig deep, but obviously that's time consuming, that's resource intensive. And I think we collectively as a profession can sort of think hard about what are some general rules and sort of general guidance we can follow to make the process more efficient.
Yeah, I mean, I guess I have one concrete piece of advice for folks out there. You got to call Michelle and call Paul, I guess, if when you run into these things. So thank you, Paul. Thank you, Michelle. Really appreciate this discussion. Everyone out there, I hope you enjoyed it as well. That's us signing off. Thanks again.